Can a provision in a contract be so unconscionable that a court refuses to enforce it? We'll see whether a court enforced a compulsory arbitration clause in an employment contract in Stirlen versus Supercuts Incorporated. In January of 1993, Supercuts hired William Stirlen as Vice President and Chief Financial Officer. Stirlen had to sign an employment contract with an arbitration clause, holding that employees must submit all claims to arbitration. The clause also limited all remedies for employees to breach of contract damages. However, the contract allowed Supercuts to sue employees in state and federal courts, and there weren't any limitations on Supercuts' remedies. Stirlen explained that the employment contract was given to him on a take-it-or-leave-it basis. All corporate officers at Supercuts were given the same standardized contract. In late 1993, Stirlen told Supercuts' President and Chief Executive Officer David Lipson that there were some accounting irregularities concealing Supercuts' decline in profits. Stirlen told Lipson that the accounting irregularities may have violated state and federal laws. After Stirlen raised his concerns, Lipson fired Stirlen. Stirlen sued Supercuts and Lipson, collectively referred to as Supercuts, for wrongful termination. Supercuts moved to compel arbitration, citing the arbitration clause in Stirlen's employment contract. However, the trial court denied Supercuts' motion. The court held that the arbitration clause, when viewed in its entirety, was unconscionable and unenforceable. Supercuts appealed to the California Court of Appeal.